All right, sorry guys. There actually is some big news from today. Today, the Supreme Court heard arguments pertaining to Trump's desire to end birthright citizenship, and particularly with regard to nationwide injunctions from federal judges. We've talked about the birthright citizenship stuff plenty. Essentially, the argument from the Trump administration is that there's no way for the executive branch to do their job, read, break the law, if federal judges can issue injunctions nationwide against them on the grounds of something being unlawful or potentially unlawful. That is, in fact, the jurisdiction of a federal judge. That's the point. They're a federal judge. The practical consequence of limiting nationwide injunctions, if it happens, which, by the way, if it happens, would be insane because it would contradict a bunch of jurisprudence, but, you know, we live in insane times. The consequence of this would be, even if something was unlawful or unconstitutional, judges would not be able to stop the federal government from engaging in that behavior. Instead, if you were the victim of that behavior, you would have to sue the federal government and win that lawsuit for you personally to be given restitution. So in the case of birthright citizenship, if the court found that birthright citizenship is the law of the land, but limits nationwide injunctions, what that could essentially mean is, legally, the federal government can't deprive you of your citizenship. So every single person whose citizenship is deprived of them then has to personally sue the government and go through years and years of litigation, expensive, hundreds of thousands of dollars. And maybe they win. Maybe. Because we know how the system works. Maybe they win. And then, and only then, would they be given their citizenship back. In effect, ending nationwide injunctions would end the law when it comes to dealing with the executive. I've heard arguments that this would have similar consequences to the Enabling Act in 1930. It's 1930s Germany. Yeah, it's in the ballpark, I would say. It's in the ballpark. I would say it's in the ballpark. Aren't we supposed to have like an amendment in order to end birthright citizenship? You're not understanding. The point of this would be that the executive branch could do whatever it wanted, whether or not it's unconstitutional, because judges could no longer issue injunctions against the government. You would need to, it would be as if, like, legally, it would be treated as though the government had committed a specific crime against you rather than a policy crime that is unconstitutional towards the entire nation. It would effectively make it impossible to challenge the federal government on anything. Where's the statements? Hearing arguments. Okay, that was the same article that I was just on. Where were their statements? Give me their statements. Court's liberal justices seem firmly in support of the lower court rulings. Of course. If the government wins on today's arguments, it could still enforce the order against people who haven't sued, Kagan said. All of those individuals are going to win, and the ones who can't afford to go to court, they're the ones who are going to lose. You have to sue the government to keep them from violating your rights. It would literally be incomprehensibly cucked of SCOTUS to say injunctions aren't allowed. It would also be, how do I put this? It would be extremely authoritarian, but also in a way that's completely non-functional. Because this would mean, like, I want you to imagine this in any other context, like any country where the government, by rule, violates its own constitution openly, constantly against millions of people, and you can beat them if you just sue them and have the money to do so. But if you don't, you get the shit end of the stick no matter what. All court systems are permanently bogged down by the millions and millions and millions of cases against the government, money funneling into the state and lawyers as everyone tries to be, you know, one of the lucky ones who get to personally sue for their own constitutionally protected rights. It's insane. It's absolutely insane. I can't think of any other country that works like this. It's like a broken system. It doesn't function. It's a non-functioning system. So, of course, it's what they want. When can we expect to hear a ruling? A decision is expected by the end of June. So, we'll hear. We'll hear soon. Let me see if I can find some excerpts from the transcript. Supreme Court nationwide injunction arguments. Quotes. The Supreme Court on Thursday seemed open to lifting a series of nationwide orders blocking Trump from enforcing his birthright citizenship policy, even as several of the justices wrestled with the practical implications of allowing the government to deny citizenship to people born in the U.S. and of limiting nationwide injunctions. If there's one thing that I truly, truly hate about the Supreme Court, it's how f***ing rules lawyery there are about things that you don't need to be a rules lawyer over. The claim being made by the Supreme Court, or sorry, by the Trump administration is absolutely psychotic. It doesn't work. Justice Neil Gorsuch at one point ruminated about the patchwork problems of allowing enforcement in some parts of the country but not others. Jesus Christ. The musing over it, you know, like, will we issue a decision that breaks the country? This shouldn't even be in front of SCOTUS. It's so open and shut. Well, normally procedural stuff like this, questions over procedure, they don't make it to the Supreme Court. This is pretty unusual, like at the face of it, you know? Normally the Supreme Court talks more about the substance of an issue, you know, like what's the underlying argument. In this case, they're just talking about, like, essentially the nationwide injunction element. The fact that it's about birthright citizenship is almost incidental. Kavanaugh, a member of the conservative wing who sometimes sides with the liberals, suggested that class action lawsuits would suffice for allowing the challengers to Trump's executive order to get broad relief from the courts. He brushed away the suggestion from challengers that relying on class certification as a tool raises many of the same issues as nationwide injunctions the president is complaining about. That's great. That's good. The Trump administration has pointed to class action lawsuits as being the proper vehicle for courts to issue orders that would broadly block enforcement of unlawful presidential policy while the issue travels up higher courts. But liberal justices on Thursday and conservative Justice Amy Coney Barrett grilled Solicitor General D. John Sauer on the possibility that the administration would even fight in court against a request for class certification in this case. Oh, it's grim. The court's three liberals battered Sauer with questions about how rolling back nationwide injunctions would work in practice. They quickly sought to move the debate beyond the Trump administration's assertion that its request was a modest one, dealing with the technical issue of limiting the reach of nationwide injunctions. The president is violating not just one, but at my count, 4 established Supreme Court precedents, said Justice Sonia Sotomayor to Sauer. And you are claiming that both the Supreme Court and no lower court can stop an executive universally from violating those holdings. Let's just assume you're dead wrong, Justice Elena Kagan said at one point. Does every single person that is affected by this EO have to bring their own suit? Are there alternatives? How long does it take? How do we get to the result that there is a single rule of citizenship that is a rule that we've historically applied rather than the rule the EO would have us do? The court's conservatives engaged with that discussion less, but several nonetheless raised the issue. Notably, Kavanaugh pushed Sauer on how hospitals and states would deal with the order if it were allowed to be implemented tomorrow. On the day after it goes into effect, this is a very practical question. How it's going to work? What do hospitals do with a newborn? Kavanaugh asked. Sauer said that federal officials would have to figure out the implementation. How? Kavanaugh demanded. So you can imagine a number of ways that the federal officials could, Sauer said, such as? Kavanaugh continued, seemingly skeptical. Wait, complete the statement. Give me the audio.
Things can happen that need to happen for 30 days or some period of time, or should we not even worry about that?
Yes, we can see that the 30-day ramp-up period that the executive order itself calls for never started because the universal TROs were entered almost immediately, and we don't dispute that there should be a 30-day ramp-up period. For another reason as well, which is that we've been enjoined from even doing guidance, even formulating a policy, and that itself is another problem with these injunctions.
On the day after it goes into effect, this is just a very practical question how this is going to work. What do hospitals do with a newborn? What do states do with a newborn?
What the executive says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out.
How?
So you could imagine a number of ways that the federal officials could,
Such as?
they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B1 visa, which would exclude kind of the birthright citizenship in that country.
For all the newborns? Is that how that's going to work?
Again, we don't know because the agencies were never given the opportunity to formulate the guidance.
So, for one, you could have formulated the guidance even with the injunction out, you stupid piece of shit. Second of all, what D. John Sauer, U.S. Solicitor General, is saying essentially is that for every single newborn currently held in a hospital who hasn't yet been presented with all of its documentation and paperwork, all of the parents of those kids would need to bring their like proof of citizenship to prove that that at least one of them is a U.S. citizen, so that they wouldn't be subject to the birthright citizenship ending executive order. And if they don't do so, if they can't prove that, effectively that would be a stateless baby. Like that baby would essentially be condemned to a life of wretched misery anywhere in the world. I mean, unless they could be granted citizenship for a different country, but that's not necessarily guaranteed, like, at all.
They're only going to have 30 days to do this. You think they can get it together in time?
They're under. That's what the executive order instructs them to do, and hopefully they will do so. Again, it's a speculative and hypothetical scenario because they were enjoined from even starting that process.
Also, the argument that he is making to the Supreme Court of the United States when asked a very, very basic question about what the effect of an executive order would be if it was implemented is, well, we haven't written on its implementation yet because we weren't given the chance to, when he signed the executive order. So they're essentially saying not only did he sign the executive order with no plan whatsoever on implementation, but we still haven't produced one. And the only reason we haven't produced one is because the injunction somehow prevented us from creating the documentation should it ever be allowed through. They have no plans. They don't care. They wrote the EO. They told ChatGPT to write the EO, and that's it.
And then last question. You mentioned before this has come up in the last 4 or 5 administrations primarily. I guess I've thought about that a lot too. Why? It seems why might be it's harder to get legislation through Congress, particularly with the filibuster rule. Presidents want to get things done with good intentions. The executive branches that work for those presidents push hard to, when they can't get new authority, to stretch or use existing authority, and they've been pushing, understandably, all with good intentions, all the presidents, both parties, right, with good intentions, pushing. Is that your understanding of why this has happened more, that there's less ability to get legislation? Because I'm trying to figure out the why to your opening about the last 4 or 5 administrations. I agree with it. I think that might be the why, but I'm curious what you think.
I'm speculating about the motivations of the individual district judges who grant these, but one explanation might be this is an extraordinary power. It's a very strong power for the reasons the questions have reflected.
Well,
for a district
let me just pause you right there. The underlying point is
Keep in mind, by the way, any arguments that Trump supporters make about how there's something unworkable about how all of these federal judges have the ability to issue nationwide injunctions. I admit there is sometimes like an inefficiency, like a kind of an unworkability to that system. But remember, they want to prevent the Supreme Court from doing that as well. They've explicitly said in the administration, it's not just the federal injunctions coming from the lower courts. They want to prevent the Supreme Court from being able to issue injunctions as well. So it has nothing to do with stalling or preventing the execution of executive orders or anything like that. It's purely just freeing yourself from the judiciary, which is exactly what they're trying to do.
That these district judges are not just doing universal injunctions, they're finding these actions illegal because they're exceeding existing authority, and oftentimes we are too, when it gets to us, finding the actions of presidents of both parties unlawful because they exceed existing authority. So is that coming up more often? Why is that coming up more often?
It's hard to do an historical analysis, but I would draw an analogy to the New Deal. And Professor Bray makes this point in his article that actually there were very, very passionate challenges to sort of nationwide policies during the Roosevelt administration, and they were not addressed by issuing universal injunctions. He cites an example where in one case a policy had been held illegal, and there were like 1,600 injunctions against that policy, all protecting the individual plaintiffs. So if you look at the history, it's not clear that what we have of disagreement, but difficulty, gridlock, getting things through Congress and so forth, that's not necessarily new. What is new, and is certainly unique to the last 5 presidential administrations, is having these given on this widespread basis and this systematic basis, 40 again in the last 4 months.
Thank you.
Justice Barrett?
General Sauer,
Have you considered perhaps violating constitutional law less often?
I want to ask you about a potential tension. Well, no, not potential tension, an actual tension that I see in answers that you gave to Justice Kavanaugh and Justice Kagan. You resisted Justice Kagan when she asked you whether the government would obey within the Second Circuit a precedent. I'm distinguishing between opinions and judgments here. Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice. It is, and that is not
This administration's practice or the longstanding practice of the federal government? And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding policy of the Department of Justice, yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. In some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay, so I'm not talking about a situation in which, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit.
Oh, no, he is the guy who argued that the president should legally be able to potentially assassinate his political opponent, and that would fall under the auspices of official presidential duties.
Holds that the executive order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, long-standing policy of the federal government to take that approach?
That is my understanding.
Okay, but it sounds to me like you accept a Cooper versus Aaron kind of situation for the Supreme Court, but not for, say, the Second Circuit. Like where you would respect the opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well, but my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly addresses that, and we stand by that completely.
Okay. Next question. So this is also a follow-up to some of the questions that others have asked you about the merits of the order not being before us. Did I understand your answer to be because you think percolation is really important for this one?
We do think percolation is really important for this one, but the reason the merits are not before is because we've only submitted a stay application on the scope of relief question, and as Labrador against Poe indicates, the scope of relief is a separate question for the.
Oh, I understand it's a separate question, but there are plenty of times that the government comes to us and asks for both.
Absolutely. For example, recently in the Wilkins and Cox application, we did exactly
And
that.
the reason why you didn't ask for both here is because you think that the merits question needs percolation.
Yes, but also more fundamentally, it illustrates that the very problem with these nationwide injunctions is they force this rushed, fast and furious decisions on the merits. So I think it'd be very inappropriate in this case to come to a stay application saying, please give us a rushed, decision on the merits of something that's very, very complex.
But the government's done that in other cases too, right?
Those cases would be different in this case. The example I gave earlier, we think it's very clear cut on the merits. This one is, we concede a novel and sensitive
So this one
question.
isn't clear cut on the merits?
This one, in this case, we want the court to address the remedial issue. If we offer the merit first, that's a vehicle problem because the court has, in many cases, just addressed the merits and not the remedial issue. And it's imperative from the federal government's perspective that the remedial question be addressed.
Okay, so last question is about why that is. Justice Alito asked you well, what's the point of this? If the same thing could happen, which is effectively the EO being enjoined everywhere via class action or because it's necessary to provide complete relief, say, to the states, is there any difference in your view between, say, a class is certified of all individual plaintiffs and they win, and the executive order class-wide, there's a judgment saying that it can't be enforced? Do you want to say, follow up, is there any practical distinction you see? Why does the government care? Is it just the rigors of the certification process, or is it something more?
The rigors of the certification process. Keep in mind that in many of these cases, we successfully oppose class action.
Let's assume, I think, you can't successfully oppose it here for individual plaintiffs.
Well, I mean, that opportunity to have our day in court on that is very, very important.
I understand, but let's assume, go with my assumption.
Assuming that we were to lose in
Assume the class is certified. Is there any benefit? If a class is certified, and let's say, you were pointing out that the executive order targets two different kinds of people. Let's assume that it's commonality because, they only target one portion of the order, right? In that circumstance, does the government get anything different? This is back to Justice Alito's question about what's it to you? What's the practical difference to you? Do you want to say anything about whether there's a practical difference between a universal injunction and a loss in the class?
Absolutely. Okay. Among many others, the represented class members are bound in the class action context. And that means that if they lose, they're bound by that as well. So they're taking a grave risk.
I knew there was a reason for us to listen to this directly. He says it right there.
The represented class members are bound in the class action context. And that means that if they lose, they're bound by that as well. So they're taking a grave risk, so to speak, by proceeding through a class action. And
what he's essentially saying is that when the federal government does something unconstitutional, they don't want a nationwide injunction. They want all the victims of that bad unconstitutional policy to file a class action lawsuit. Because if somehow that class of people loses, they're bound to the loss. Whereas with an injunction, you have this ongoing legal dispute. You can settle it with a class action lawsuit. So leaving aside all the difficulty and time and cost of assembling a class action lawsuit to challenge the government on, say, the unconstitutional end to birthright citizenship, which would, again, like millions and millions of people would be roped up in this, right? He's essentially saying, well, the goal of this is that once they lose, that's permanent.
And it has this symmetry where the government is bound if we lose, they are bound if we don't lose. And that's a very, very important distinction.
And you would respect that judgment?
If it were, yes, if it were a judgment. Now we may try to litigate in other contexts to try and get a different judgment from a...
Jesus Christ, man. Oh, yeah, we want a class action lawsuit because that way if they lose, they're bound forever. If we lose, of course, we're the federal government, so we can actually, shop around for, different judgments because, again, we're the federal government. We also directly bully judges who rule against us.
A different
Sure.
district court, but we would be bound by that judgment, as would they, and that's the crucial point.
Okay.
Justice Jackson?
So as far as I can tell, your bottom line seems to be that what you call universal injunctions give relief.
Yeah, to not be the victim of explicitly unconstitutional behavior, your entire class of people have to win every time, and they only have to win once. And the person you're up against is the federal government with essentially infinite power, money, and legal representation who can shop around for as many judgments as they want. They can appeal as many times as they want. They have no limits on what they can do, and they threaten and bully judges who rule against them. So you do the math.
To non-parties without going through the necessary steps, which you identify in Rule 23. Do I have that right? I mean, is that sort of like boiled to bare essence what you're saying?
I would say there's a lot more to it, but that's one very important point.
That's a key point that I want to focus in on for a moment. I guess I don't understand why you are saying that these kinds of injunctions are giving relief to non-parties. First of all, I think they can be also easily characterized as focusing only on the defendant pursuant to the court's jurisdiction, personal jurisdiction over this person relative to the subject matter jurisdiction that the court has, and the relief is telling the defendant, stop doing this thing that the court has found to be unlawful. So rather than characterizing it as a quote-unquote universal injunction, I think one could easily see that this is just about the extent to which the court can constrain a defendant over whom it has personal jurisdiction. Can it do so completely or just partially with respect to, just say stop with respect to this plaintiff? Am I I don't understand where this idea of universal injunctions comes from in this context.
I think the relevant distinction is an order that orders, in this case, the government defendant to cease allegedly unlawful activity as to the parties who have come into court and sued, and one that says to the government defendant, cease the allegedly lawful activity against everyone in the entire world.
No, just cease it. Just stop. This thing, this executive order, we do this in the APA context all the time, right? The statute says you hold that you set aside the conduct, right? That it's unlawful. And we don't really parse it out and say, okay, but it's unlawful only as it applies to the plaintiff or not. So it's a very common concept for the court to enjoin a defendant from doing particular unlawful behavior. And what you're now asking us to do is to require that the court have an additional limitation in its order that says you only have to stop doing this with respect to the plaintiff. And that's the part that I don't understand. I guess, from what I can read from your papers and what you've said here, that limitation, you say, comes from this principle that if you don't do that, you would be somehow giving relief to non-parties. But I wonder if that's right. It seems to me that the relief...
His argument essentially is that it's not fair that the president can sign an unconstitutional executive order and a judge can put a hold on it when the executive order might have contained something that wasn't unconstitutional. Like, essentially, if Trump signs the EO, banning non-whites from entering the country, but also appointing a new committee on an investigation of racial purity within the United States, which would be lawful, and that gets enjoined or there's an injunction. They're whining like, well, what about the committee? You shouldn't be going after all of it. You could just have constitutional executive orders, I guess, if you want.
Is the judgment that you provide to the plaintiff that says, stop doing this conduct. And you give it only to the plaintiff. That's where the limitation comes. The plaintiff is the only person who can go to court after you violate this order and enforce it. Other people are incidental beneficiaries of a court ordering you to follow the law. That's like everyone in the world. When the court says, follow the law, anybody who would have been hurt by your not following the law benefits. Okay. I don't understand why that would limit the court in its ability to tell you, don't do this unlawful conduct.
Two responses to that.
Yes.
There's a lot there. Two responses to that. One is that principle that your question referred to is the holding of the court in Worth against Selden, and it's reaffirmed in Gill against Whitford, in Lewis against Casey, and similar cases. That's
not the argument. The argument is that courts should only have the right to stop the government from doing something illegal against one person at a time. It's both. They're making both cases. One, that only the plaintiff should be able to bring it forward, and two, the idea that you have these broadly applicable rulings, injunctions against the entire order, when not just the affected parties. They're splitting groups into, it's like two subcategories, right? There's the plaintiff and non-plaintiff, and then there's the affected and the unaffected by the unconstitutional behavior. And essentially, they're trying to particulate it down to the finest possible grain, where they're like, well, actually, it shouldn't be illegal to have a murder for hire business. Instead, every victim of the murder should then have to sue you, and if you lose that lawsuit, then they get to collect from you. That's essentially their argument. It sounds insane, but that's essentially exactly what they're arguing. It's completely incompatible with the concept of rule of law, that unlawful behavior should be allowed to propagate knowingly until the plaintiff succeeds in a lawsuit, even when the fact, like, it's factually known that the behavior is unlawful to begin with. It doesn't work. Like, this is civilizationally ruinous. But this is always how fascist regimes go, right? They don't apply a consistent set of laws. They throw out an insane jumble of weird, unworkable, inconsistent, extremely biased laws, and then they follow them in whatever way benefits them.
The authority of the federal court, whether it's viewed as arising under Article 3 or under its traditional scope of equitable authority, is to remediate the injuries to the complaining party. And then to address your question about...
Can I just stop you there? I'm, as the court, remediating the injury by telling the defendant to stop doing this behavior. The plaintiff has brought a claim that this executive order is unlawful. I look at it, I litigate it, and I say, you're right. Stop doing it. You cannot enforce this order. So I don't understand why that's like outside the scope of Worth versus Selden.
If the court in that case is imposing what we've called an indivisible remedy, for example, vacator under the APA, there's a debate about what set aside means. Assuming it means to vacate, then the remedy that Congress has provided as a condition of its delegation to the agency is if one part of the, if the regulation is unlawful, then the remedy granted, which directly remediates the plaintiff's injury on that hypothetical, is an indivisible remedy that benefits others. Here in this case, and in all the other 40 cases, we see something totally different.
Yeah, I understand.
It's not necessary to remediate the injuries of the plaintiff before them. That is the
I understand. Let me just turn your attention to one other thing, because the real concern, I think, is that your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights. Justice Kagan says, let's assume for the purpose of this that you're wrong about the merits, that the government is not allowed to do this under the Constitution, and yet it seems to me that your argument says we get to keep on doing it until everyone who is potentially harmed by it figures out how to file a lawsuit, hire a lawyer, et cetera. And I don't understand how that is remotely consistent with the rule of law. A system, and I appreciate that you go back to English common law and the Chancery Court, but they had a different system. The fact that courts back in English Chancery couldn't enjoin the king, I think, is not analogous or
It's very telling, by the way, that he would cite that as a positive example to his argument. Well, if you go back to the origins of our legal system, a judge couldn't enjoin the monarch.
Indicative of what courts can do in our system, where the king, quote unquote, the executive, is supposed to be bound by the law. And the court has the power to say what the law is. And so one would think that the court could say, this conduct is unlawful and you have to stop doing it.
I think the catch-me-if-you-can problem operates in the opposite direction, where we have the government racing from jurisdiction to jurisdiction, having to sort of clear the table in order to implement a new policy. A great example of this is
that stop doing stuff that's unconstitutional. It's again, this is all what critical legal theory is all about. The idea that these laws are being applied like in a morally and contextually neutral ground or whatever. It's like, well, no, you don't get the same privilege to make that statement because you're in the wrong. You're the one doing the unconstitutional behavior, man. All this is happening because you keep getting enjoined in court. This is not happening in the other direction.
In the Schilling litigation, where the military had a military readiness policy, it was universally enjoined by the DDC. It went up to the DC Circuit. The DC Circuit stayed that injunction to allow that policy to go into effect, and then 1 hour later, a district court on the other side of the country universally.
Can I just ask you one final thing, because this relates to also something that Justice Kagan said. I would think we'd want the system to move as quickly as possible to reach the merits of the issue and maybe have this court decide whether or not the government is entitled to do this under the law. Wouldn't having universal injunctions actually facilitate that? It seems to me that when the government is completely enjoined from doing the thing it wants to do, it moves quickly to appeal that, to get it to the Supreme Court, and that's actually what we would want.
This is a good point. Even if it weren't for the fact that the Trump administration wants to do like unambiguously unconstitutional shit, the current system of injunctions really doesn't move that slowly. The only reason it feels slow in comparison to like the current political, I guess, age is because the Trump administration's firing out insane shit every day. It would be much, much slower to assemble like class action lawsuits against every unconstitutional thing the government did. There have been days where Trump has signed multiple unconstitutional EOs back to back. Do you have any idea how long it would take to be able to muster the and to move that through the legal system? We're talking at minimum multiple months, but in all likelihood, in reality, probably years. By the point it concludes, a lot of the people who might have their citizenship restored would have already been deported. So, yeah.
What I worry about is similar to what Justice Kagan points out, is that if the government is saying no lower court can completely enjoin it, it actually means that the government just keeps on doing the purportedly unlawful thing, and it delays the ability for this court to reach the underlying issue.
Percolation of novel, sensitive constitutional issues is a merit of our system. It is not a bad feature of the system.
Thank you.
Thank you, counsel.
Weasley non-answer. I would be very surprised if this court ruled in favor of the executive. I would be very, very surprised. But also, we do live in shitty, shitty times, so who knows? The liberals will vote against. Amy Coney Barrett will vote against. Kavanaugh will probably vote against. Kagan will probably vote against. Roberts, I give it a coin flip. I don't know. Gorsuch and Thomas, probably they'll vote in favor, I imagine. I'm pretty sure that Thomas has already, like, himself written on putting an end to federal injunctions anyway. Like, I'm pretty sure he's talked about this. If we get a 7-2 with Gorsuch is really pissed because this ruling is going after Native American citizenship rights, so he's probably know. Oh yeah, Gorsuch is really like hawkish on Native American rights for some reason. He voted in favor of that land back proposition. For some, he's a complex, multifaceted. Yeah, okay, no, I forgot about that. You're right. I guess I'd give it to Alito and Thomas then. 50-50 on Roberts, because I hate him. I hate Roberts almost as much as I hate Thomas. Who's more evil, Alito or Thomas? Thomas. Kagan's one of the liberals. I'm sorry, am I completely gorked out of my fucking mind? Am I blanking right now? Kagan's a good one. I'm sorry. I'm so sorry. You meant Alito? I meant Alito. I was looking at them right next to each other. I think native treaty rights are Gorsuch's hyperfixation. Well, if it works to our benefit. Look, you got to take advantage of whatever, like, edge case support you can from these fucking monsters, right? Like, Amy Coney Barrett has been, I won't say wokeness's strongest soldier, but she sided with us in a couple of pretty pivotal moments. So she's definitely not a hardline MAGA warrior like they wanted her to be. Yeah, I don't know. I guess we'll see if we still have a country by the end of June.